Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. Okay, you're watching Dr. Stephen Cook, an emergency physician, on the stand in the Todd Kendhammer case. Now, right what you see are, I think, about maybe 3 or 4 jury questions that are going to be asked of this witness. Interesting case where the jury is allowed to ask questions of the witness. And what you just saw the testimony was this is a defense witness, and basically saying that after reviewing the injuries to Barb Kendhammer, her injuries are consistent with the story put forward by Mr. Kendhammer, that this was an accident, that a pipe did pierce the windshield, and the injuries that she suffered was a result of her moving around the car and things like that. And then he was really questioned under cross-examination about his expertise. So it's going to be interesting to hear what these jury questions are. The judge is reviewing them right now, and we'll wait and hear. Let's take a listen. Again, you're just waiting for the jury questions for this witness, Dr. Stephen Cook, in the Todd Kendhammer case. I'm here with Aaron Keller, our very own specialist right now. Aaron, you're seeing this. What do you anticipate for these jury questions after this witness just testified?
Well, boy, if yesterday is any indication, Jesse, then these jury questions might really rip into the witness. The jury questions we saw yesterday really seemed to lean strongly towards a conviction. You know, look, they've got to ferret out the questions here, because jury questions, just like questions from attorneys, are subject to objections. So if the questions go well beyond the scope of the witness's expertise, they can be objected to. They can be objected to for other reasons. So that's the process that's going on right now, just from a process standpoint. But yesterday, the questions seemed to lean very strongly towards a conviction. And yet the questions yesterday also bothered me a little bit, because I think they tended to go in areas that the witnesses weren't really qualified to get into. So I'm wondering if the judge is going to keep these questions on a little bit more of a short leash today. So, you know, for instance, if I'm a photography expert, I'm not going to testify about the victim's cuts and injuries.
Right. Right. I'm curious what you thought of this gentleman's testimony, basically that the injuries were consistent with a car accident, and that, you know, she was unconscious, her body would be swerving around, she tried to, the pipe must have hit her at different parts in the head. It also, because something would be coming towards the windshield, she might have ducked down, and then she was dragged from the car. So did you think it was at least impactful for jurors on his direct examination? You think it's a believable story? And he was very animated, moving around, showing it. I thought he was a pretty good witness.
I thought so as well. Some people in the chat rooms were more entertained than not about this particular witness. Sometimes the expert testimony can be rather dry, and in this case, yes, he was an animated speaker. So that made it easier to watch his points from a television perspective. But as to the jury, look, the bottom line is that this defendant's story is really hard to believe. But the fact that it almost sounds, at least in some fashion, in some version, plausible, that's going to be the sticking point, I expect. Because, look, it's one thing for us to sit here and say it's more likely than not that the story is bogus, because it's just so unbelievable. But if there's a grain of truth behind it, we have to couple that with what we know of the burden of proof. Can this prosecutor prove beyond a reasonable doubt that the defendant really committed first-degree intentional homicide? That's the top charge in Wisconsin. That's where the sticking point's going to be.
And I think the biggest asset for them Yeah, and we'll get back to that after these jury questions.
5:30. Could the neck abrasions have been caused by glass or the seat belt rather than the Bubba mug?
Seatbelt can do abrasions along those lines. In general, you have to have a lot of rotational force to get far enough up the seatbelt for it to do it, but that's not an impossibility with it. And yes, the glass on that picture, the 2 or 3 areas that looked like they were little scabs or little, they were almost round or square areas, those are certainly consistent with glass cuts. That's exactly what glass cuts look like when you get them in an automobile process. It's fragmentary stuff, and you get little cuts and little bleeds. It's all tiny little nicks and cuts. So yes, could be very consistent with that. Seatbelt can cause abrasion process to the neck, but the reason they put the seatbelt harnesses and everything the way they've designed them in cars is so that you tend not to, even if you fall to the side, have the neck be the primary area where impact force occurs.
Okay, thank you. Again, don't take any notice or heed of questions I could not ask. All right, we'll take our break at this point.
Can I see exhibit 530 again? There's no checks.
Okay.
One second.
Okay, we'll take our morning recess. You step out, enjoy your break. Don't talk about the case. We'll have you back in maybe 15 to 20 minutes.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. They're taking a break now in the Todd Kendhammer case out of Wisconsin. You saw the testimony of another defense witness, and again, let's not forget, we anticipate the defendant, Todd Kendhammer, taking the stand today. You're not going to want to miss any of that. I'm here with Aaron Keller right now to talk about what we saw this morning. We were just talking about in our voiceover as we were watching this about this witness and the idea that under cross-examination they were really hitting him on the fact that what exactly are you an expert in, sir? I mean, we know you're an expert in the ER injuries, physical injuries that you've seen in ER training, but you don't know anything about biomechanics. You don't know anything about glass. You're not a blood analyst. That has to be really effective when you really question a juror like that, question a witness like that.
Well, I think so, but the flip side is, look, not every one of these experts is going to be an expert in everything, and I think that the defense is called a myriad of experts to try to fill in gaps that the prosecution's experts, frankly, had in their own knowledge and expertise. The prosecution gets a guy from the crime lab up there who, by the way, was under fire in the Stephen Avery case for potentially contaminating some of the evidence. The same guy still works in a crime lab in Wisconsin. Stephen Avery, of course, the Making a Murderer case. But, he's up in this case talking about the way the glass broke and this, that, and the other thing. And the only education and experience he really has with glass is a 3-week course, which covered things other than glass. So, look, the defense called a glass expert. The defense called this emergency physician. The defense called the biomechanics expert. So, of course, all of them are going to have different viewpoints, but they're looking at things from one perspective, then another. My guess is that the defense is doing what the defense is trying to do, which is collect nuggets from each witness and then hope that it results in a payday on closing argument.
See, on one hand, it seems like possibility versus possibility. It's possible that this was an accident. It's possible this was a murder. The reason I think, correct me if I'm wrong, when the prosecution closes their case, they're really going to focus on this. Where's that flatbed truck? I don't know. I don't know where it is. I have no evidence of a flatbed truck. We couldn't find it on surveillance footage. And then also, we talked about this earlier, that the day in question, what the activities the Kendhammers were supposed to be doing, going to this another person's house to fix a windshield, this guy didn't even know that they were coming. So I think those two aspects, when you take it away from the crime scene, favors more the prosecution, and they might want to harp on that a little bit more. What do you think?
Well, you know, as to the truck, I don't know if that's as big of a sticking point as some other issues are in this case, because look, we already know from the testimony that, first of all, they didn't review a broad enough swath of the surveillance camera footage to indicate that the truck may have been, for instance, making local deliveries or stopped somewhere. They reviewed plus or minus about a half an hour in the various cameras. So if the truck drove past one of the cameras, made a stop, or perhaps even originated from a house in the area, then it wouldn't show up on the surveillance cameras that they reviewed. That's one thing. And the second thing, which I think is the most dispositive fact about the truck and the surveillance cameras, is that there are other ways in and out of the incident location where the truck wouldn't have passed any surveillance cameras. So I don't think the surveillance cameras are dispositive.
That's a big factor, though, I think.
Well, okay, so if there are 5 ways to get to Jesse Weber's house, and there are only cameras on 3
One
of
way.
them,
I live on a moat. It's a moat,
okay, well, you know, your castle is unique. Most people could take several ways home, and look, I mean, I walk different ways to the train station every day, depending on what I feel like doing. So because I don't walk past one street corner one day doesn't mean that I don't walk past it another day.
But can a juror just think, oh, isn't it so convenient that we can't find this mysterious flatbed?
Well, they could. Okay, it's probative, but it's not dispositive. It doesn't prove the fact definitively one way or the next. It's a nugget of information that certainly is relevant.
I agree with you. Now let's talk about really what's going to happen today. When this defendant takes the stand, okay, isn't it going to be a little bit like what we saw in that interrogation tape, where he's going to have trouble explaining a lot of these injuries and what happened? You saw him stammer in that tape, and do you imagine under cross-examination it's going to be very similar?
Well, it might be, but look, Jesse, does he have to prove his version of the story? Is the burden of proof on the defendant here?
It is not. It is,
okay, so you answered your own question.
All that they need to show is some reasonable doubt. I agree with you. I agree with you. But we talk about reasonable, right? The idea, and this is, I'll actually say in favor, the idea that it seemed like more of a complicated method to kill someone. It seems like an elaborate scheme to kill someone. However, the point is, it is possible. I heard that glass expert yesterday, right? Mm-hmm. The 3 impacts into the windshield. Isn't it possible that he could have staged that as well? He could have hit his hand into the windshield. Could have had the pipe.
You know, and the hand into the windshield thing is one of the points in this that really bothers me, because I don't know if I have it in me to literally punch a hole in a windshield. Okay, maybe it isn't a hole. It's enough of a fracture. I mean, talk about some force. I don't know if I could do that. Maybe if I really tried.
Don't sell yourself short.
Yeah, I don't know. Well, we'll have to meet up at the junkyard this weekend and see if we're strong enough to punch
holes. This is not an activity
I
really want to do.
And, well, you know, look, but I don't know. I mean, you know,
Yeah.
I've bumped into window glass relatively hard a couple of times, you know, struggling to get bags out of the car or something. It doesn't shatter. That takes a lot of force. So that part of the story is one of the least believable parts.
Just explain to our viewers a little bit, because I think there was confusion about this mug, this cup that was in the car, and I think what we just heard this doctor talk about was that cup could have hit her. I mean, she might have been holding it, it could have hit her. What is the role of this cup? We keep hearing questions about it back and forth. You think it could have caused some of these injuries?
Well, it might have, and this is another one of these things. Did it or did it not? I can't say dispositively, but here's the thing. Based on the injuries to her mouth and to her teeth, one plausible scenario here is that she may have literally been midstream taking a sip from this cup when this pipe went through the windshield. And we just heard the witness testify about that. Why do we think that's a possibility? Well, first of all, the cup was broken. And second of all, a piece of plastic from the cup was actually up in the windshield. So it makes one wonder if that was part of the way this thing happened. So we know the pipe didn't impale the victim. But what if the pipe hit the cup or
Yeah.
hit something and you know, look, I mean, the pipe just didn't, assuming that this pipe did go through the windshield when she was sitting in it, the pipe just didn't probably stay stationary. It's probably bouncing around in there. He's going, what, 50 miles an hour apparently when this happened. So did it cause a number of the injuries? Well, it would seem that it could have, but then we're back into the could have. And did it hit the cup? I mean, did this all line up in just such a way that she was midstream taking a sip out of the cup, the thing goes to the windshield, the cup hits her mouth, you know, the reaction causes a fracture in the back of the head. It seems far-fetched, but it has at least a tiny ring of truth to it.
I think the prosecution's going to have a field day with Todd Kendhammer on the stand later on. Aaron Keller and I are talking about the Todd Kendhammer case. Well, I want to show you right now testimony from yesterday from a defense witness. Again, the defense is putting on their case. We saw the testimony yesterday of Dr. Barry Bates. This guy is a specialist in biomechanics, human factors expert. Again, you would think a really strong witness for the defense. Didn't turn out so well. We'll talk about his testimony after this